Ladies and gentlemen, dear colleagues, I'm glad to be, oh no, I asked my colleague to help the presentation. Ladies and gentlemen, I'm glad to be here with you today and have the honor to speak to you about research conducted under the umbrella of Child Welfare and Modern Technologies Research Group. Human dignity is the intrinsic value and worth of every human being. Child's human dignity is the recognition of a child's inherent worth as a rights-bearing individual deserving of respect, protection, and participation, regardless of age, status, or capacity. Child's human dignity refers to the moral and intrinsic value of the child. It encompasses the respect for their individual identity, developmental needs, and growing autonomy, ensuring that their voices are heard and their interest is prioritized. From a Christian perspective, child's human dignity is rooted in their creation in God's image and is characterized by inherent worth, sacred life, and specific rights and responsibilities that society must uphold. The dignity of the child is the real source of their rights. Digital age has brought numerous challenges. Children are particularly vulnerable in digital environments due to their developing in identities and limited legal awareness. Online spaces are increasingly shaping socialization, education, and identity, raising new legal and ethical challenges and threats to preserving the child's human dignity. International instruments, Universal Declaration of Human Rights, United Nations Convention on the Rights of the Child and General Comment numerous 25 in 2021, at the universal level establish a comprehensive framework for the protection of children's rights, placing particular emphasis on principles such as equality, privacy, access to information, and protection from harm. Taken together, these international instruments demand a holistic approach to children's rights that carefully balances the freedoms and opportunities afforded to the children with the necessary protections across both physical and digital environments. Across regions, legal frameworks increasingly recognize the unique risks and opportunities of the digital world for children. The EU leads with detailed regulatory mechanisms. We need to mention some of the European legal acts, for example, the General Data Protection Act, the Digital Services Act, or the European Convention on Human Rights. But it should be noted, however, that not all of these legal acts are explicitly child protection related, for example, GDPR or DSA, but they do provide for the protection of children in a number of ways, for example, rules on personal data protection or in accordance with digital self-determination. The concept of digital dignity of a child refers to the protection and respect of a child's inherent human dignity in the digital environment. This includes ensuring that children are safe from online threats such as cyberbullying, exploitation, and abuse, as well as from unnecessary digital footprint, while also promoting healthy digital interactions that foster their personal growth and well-being. In the digital age, children's human dignity faces unprecedented threats arising from the rapid expansion of technology and the pervasive presence of the internet in everyday life. Online sexual exploitation and abuse represents one of the gravest dangers. Recent studies estimate that approximately 1 in 12 children worldwide have been subjected to some form of online sexual exploitation or abuse, with incidents occurring at an alarming frequency. Cyberbullying includes spreading rumors, posting hurtful messages or images, and social exclusion through online platforms. The psychological effects are profound, often resulting in depression, social isolation, lowered self-esteem, and even suicidal thoughts. Children's personal data is frequently collected, analyzed, and used for commercial purposes without their informed consent, undermining their right to privacy. Beyond commercial interest, children are also subject to extensive monitoring. The lack of transparency and control over their digital footprints leaves children particularly vulnerable in a data-driven society. Access to harmful content about children can easily encounter developmentally inappropriate material, including violent pornography and graphic content, which can have lasting negative impacts on their emotional and sexual development. Exposure to hate speech, extremist content, and discriminatory material online can further undermine their sense of safety and dignity. Collectively, these threats highlight the urgent need for comprehensive, multi-stakeholder approaches to safeguard children's dignity in the digital environment. Effective prevention and response require the active involvement of families, educators, governments, civil society, and the private sector, as well as the empowerment of children themselves to navigate the digital world safely and confidently. As technology continues to evolve, so must our commitment to protecting the fundamental rights and dignity of every child. We need to mention another risk, threat, which can endanger the rights of the child. This problem is the phenomenon of sharenting. This word comes from the words share and parenting. Now let's have a look at the difference between the two. Parenting is upholding a child's human dignity within the family is part of being a parent. But sharenting in digital age is any activity, even a one-time communication, carried out by parents or grandparents or possibly family members, which takes place in the online space, the direct subject of which is the child or any personal data relating to the child, and which violates or is likely to violate any fundamental right, personality right, or legitimate interest of the child, and to which the child, especially a child with capacity to judge, has not given his/her consent or to which he/she has expressly objected. Now let's have a look how this phenomenon is reflected in light of the case law of the European Court of Human Rights. While the European Court of Human Rights has not directly addressed sharenting in its case law, it has dealt with related issues concerning the right to privacy and freedom of expression that are relevant to understanding the implications of sharenting. A case relevant to the right to privacy is Reckless and Davulis contra Greece. The applicants were the parents of a newborn baby who was placed in a sterile unit to which only medical staff at the clinic had access. The following day, the mother was presented with photographs of the baby taken face on. These photos were taken without the prior consent of the parents. The clinic refused their complaints. The parents brought an action for damages in the court of first instance. The action was dismissed. That decision was upheld by a court of appeal, then the court of cassation dismissed it. The parents objected to both the taking and the retention of the negatives and sought legal redress in Greek courts, which dismissed their claims. The European Court of Human Rights found a violation of Article 8, so the right to respect for private and family life. The court emphasized that the right to private life includes the right to control one's image, and that effective protection requires obtaining consent not only for publication but also for the taking and retention of photographs. Since the parents' consent hadn't been sought at any stage and the negatives could be used against their wishes, the court ruled the Greek authorities had failed to sufficiently protect the child's right to privacy. Another case relevant to the right to privacy is Bogolomova contra Russia. Similarly to Reckless, this case stressed the need for consent in handling personal images, particularly of children, to protect their right to private life. It concerned the unauthorized publication of a photograph of a minor's face on the front page of a booklet promoting adoption, issued by a state-supported center in Russia. The applicant, Tatyana Bogomolova, wasn't informed or asked for consent regarding the use of her son's image. After unsuccessful attempts to gain redress in Russian courts, she brought the case to the European Court of Human Rights. The court found a violation of Article 8 of the European Convention on Human Rights, which protects the right to respect for private and family life. The court emphasized that a person's image is a core aspect of their identity and private life. Publishing a child's photograph without parental consent constitutes an interference with these rights. The court held that the Russian authorities failed to provide adequate protection for the applicant and her son's private life, awarding them compensation for pecuniary and non-pecuniary damages. Examining the ECHR case law, we can conclude that in the cases examined, the basis for the infringement was the lack of consent of the parents as legal representatives. In the case of sharenting, however, the root of the problem lies precisely in the fact that the parent is the party to the infringement. It is the parent who makes public photographs, videos, and other data about the child in violation of his or her rights to privacy, including the right to human dignity, but also the right to digital self-determination. This infringement by parents has been recognized by many countries, and in 2024, France adopted a law to protect children's images, amending the Civil Code and the Criminal Code on several points, stating the sharenting is a crime. In Italy, the first sharenting case was published in 2017, followed by several others since then. The problem is also present in our country, but there is no case law yet. In the context of sharenting, we should also note the issue of the conflict of interest between parent and child, which, although the Hungarian legislature provides a solution by appointing a guardian on a case-by-case basis, but in practice this is unrealistic. Although the Civil Code provides for a person with limited capacity to bring legal actions, even against his or her parents, this may not be desirable for a family law perspective. It would be essential for the Hungarian legislature to create a stronger regulatory framework against sharenting, following the French example, even if only by means of criminal law. State intervention is needed here, either to ban the phenomenon of sharenting or to limit it to a very strict framework in order to preserve human dignity of the child. In conclusion, one may underline that upholding a child's dignity online requires a multifaceted legal approach. Parenting needs to win over sharenting, and state intervention is essential. Legal systems must evolve with technology while keeping the best interest of the child as a primary concern. Children's voices and rights must be central in shaping the digital future. Educating parents is a key in preserving children's dignity in digital age. Thank you very much for your kind attention.